Her for her leadership with Missouri MOAAIDD as our past president, and the board would like to honor her with a little token of our appreciation. Thank you, Kyla. Okay, so we're going to shift gears just a little bit because I wanted you to know what's happening in Missouri in relation to our probate law. We're very fortunate that we've got Dolores Sparks and Jim Horn here. They are co-chairs of the MOAAIDD project. So they're going to take about 30 minutes to tell you about what's happening in Missouri, what you can do to support them, and then Jonathan's going to wrap up with some healthcare conversation before we go.
Thank you. It's a pleasure to be here, and I am so proud and honored to have been a part of an effort in Missouri that has taken us about 4 years of very, very hard work to put together. It's absolutely been a labor of love for me because of all of the challenges that individuals with disabilities and family members and others have shared with us around this issue of guardianship. And so the DD Council has been very engaged in trying to address some of the barriers and challenges that we have heard about around guardianship. And one of the first things that we did is convene a group of stakeholders, and we tried to include everybody that we knew that was really affected by this issue of guardianship. We brought public administrators to the table, we brought families to the table, attorneys, elder law attorneys who work with individuals with disabilities and elderly individuals. We brought people with mental illness. We tried to address the issues around dementias and other kind of things. We had some judges who were participating with us, and we just really tried to learn about this issue. We know that Missouri is heavily reliant on full guardianship. Although our current law and our current statute does have provisions that allow for lesser restrictive alternatives, most oftentimes in Missouri, if you is there a guardianship proceeding, many of those cases end in full guardianship. And what we want is for people just to have the level of protection and support that they need. We don't want them to be overly restricted. We want them to engage in supported decision making. We want the individual to be in charge. So we formed this task force, and we tried to look at what is the real barrier. Is it our current guardianship statute? Is it training and education that needs to occur? And so what we really decided was that it's kind of all of the above. But we thought that the most important thing we needed to start with was our current law. Our current law was enacted 32 years ago. So that was way before many of the services and supports that are in place now to support individuals. And so all those provisions are very dated and didn't really include a lot of person-centered planning or supported decision-making, those kinds of things. So we decided that we would look at our current law, we would, which was 108 pages long, so it's massive statute, it's very big, and we would get a group together and we would reach consensus on how we needed to modernize and update that statute. So that is the work that we've been engaged in for about the last 4 years. So we're going to go very quickly through a kind of a PowerPoint slide which will tell you kind of the major changes that we are proposing, and then we'll tell you what we need to have you do next. So we call ourselves MOAAIDD, that's Missouri's Working Interdisciplinary Network of Guardianship Stakeholders. We'll tell you a little bit about who is proposing the changes. That's this MOAAIDD group that I talked about, that it's a very broad-based group. Why did we decide those changes need to be made? I talked about that a little. How would our new chapter be organized? Our current chapter is not organized well at all. It has the minors provisions and the adults provisions all melded in together. It was really hard to find the section that you wanted. So we spent a lot of time just kind of working on organization and making it more user-friendly. What changes in terminology have we made? As you can imagine, from 32 years ago, there's a lot of outdated terminology in our chapter. What changes have we made are we recommending to the appointment process? Any new rights for the wards? What has changed around conservatorship, which is really the management of the money? And how about changes in restoration and termination? about every 10 years, there is a guardianship summit that's a nationwide summit. I will tell you that Missouri is not the only state that has these challenges around guardianship and is not the only state that's wrestling with these kind of decisions. And so there's a series of recommendations that come out of these guardianship summits. And one of the recommendations of the last summit was that states form these working interdisciplinary networks of guardianship stakeholders to really look at these issues. And so that's why we called ourselves MOAAIDD. As I said, we've had some of our stakeholders include individuals with disabilities, parents, family members, service providers, AARP, NAMI, the Alzheimer's Association, the DD Council. We've had the Missouri Bar Probate and Trust and Elder Law Committees represented. We've had public administrators, social workers, nurses, psychologists, lay guardians, long-term care ombudsman. We have the Department of Mental Health and the Department of Health and Senior Services and the area agencies on aging. So you can see we tried to reach out and really have an inclusive group looking at these issues. And we had input from judges and national experts as well. I'm going to go quickly through this because it's about an hour presentation. We're going to try to do in 30 minutes. So this is just some kind of trends about guardianships in Missouri. As you can see, there's about 30,000 adult guardianships in Missouri. And although Missouri does have a provision for limited kinds of guardianships and alternatives, there's only about 3,000 of those. So again, very heavily relying on full guardianship. Same thing is true for the minors. We have currently about 23,000 minor guardianships in the state, and again, only about 4,000 of those are limited kinds of options. So again, we decided to first improve the law. We decided that after that, the group decided that it's one thing to make recommendations and pass legislation to change the law, but then we need to stay engaged because there's going to be a lot of education required to make sure that the judges, the public administrators, the attorneys, the people that are dealing with this statute every day really understand what those new provisions are. So we must stay together to develop policy guidance and best practice, and then also engage in training and education. As I talked about, our current law is 32 years old. Since that time, the Durable Power of Attorney Act was not even in place when our current law was written. The Healthcare Durable Power of Attorney Act was incorporated in 1991, so it wasn't in place as well. There's a lot of alternatives to conservatorship that have been created since our current law, like the special needs trusts, custodianships, and then various alternatives to guardianship like assistive technology, more emphasis on supported decision making, and those kinds of options that avoid guardianship in the first place. And estate planning is a lot different than it looked 32 years ago when our current law was enacted. We know that more and more people are being diagnosed with dementias. Again, as you saw from that slide, the need for some support is continuing to increase year by year. Although we do have limited guardian and conservatorship on our current law, it's seldom used. We know that there is a real overuse of the public administrator system. When the public administrator system was created in Missouri, it was really intended to be a last resort. If there was no family member or not someone there who could serve as guardian or custodian, a conservator, they were intended to be the last resort. And I think as we have a public administrator here, she'd be the first to tell you that's really not the way it's happening now. And they really have huge caseloads and are very overburdened in many counties because of the size of their caseload. And our current law has little guidance for what a guardian is supposed to do. There's a lot of rules and a lot of details about the money, about what you're supposed to do to take care of someone's money, but very, very little guidance about how can I support this person in the best way. Okay, a lot of our terminology is out of date. There's a lot of confusion about assets if the protectees are married. So for an older couple, where one might have to go in a nursing home and the other is in the community, There's been a lot of issues about how the money can be divided up and what the spouse who's still in the community can have and those kind of things. There's confusion about estate planning, and again, our current chapter was not well organized at all. So when we looked at the standards from those 3 national summits, which best practice across the country in the area of guardianship, we saw that our current law met some of those standards, but certainly not all of them. A very, very important issue was that in our current chapter, there is no rights for the ward. There are no rights for the ward spelled out in the chapter anyplace. It really emphasizes best interest rather than substituted judgment. There's very, very little person-centered planning required around what is it the person really wants and needs. And again, most of the emphasis was on managing the money and the property. So I'm not going to spend time on that, but that's kind of how we reorganized the chapter. We made some major terminology changes. We changed the word disabled to financially incapacitated, because just because a person has a disability does not mean they need a guardian or conservator. And we really want to get away from the thinking that it's just because of a person's disability that they automatically must have a guardian or conservator. It's about support and protection. It's not about the title. Because people do not need conservators unless they're financially incapacitated. It's about your capacity or lack of capacity. It's not about whether you have a disability or not. So we changed the least restrictive alternative, replaces least restricted environment standard, and it just means choosing the decision or approach which places the least possible restriction on the person's personal liberty and exercises of rights, and that promotes the greatest possible inclusion of the person in the community. And I know you've heard a lot about that today from John. We made a lot of changes in the appointment section. That was a huge section, and we divided that into several pieces. But one of the very important things I think we did was change clarify the respondent's attorney's duties, really resolving kind of that court-appointed versus private attorney. Whereas what happens in Missouri right now is often the individual, a guardian ad litem, is appointed. The guardian ad litem is really not there to represent the best interest of the person. The guardian ad litem is really to tell the court what they believe should happen in the matter. So there's really no one there currently that is supposed to be representing what the individual wants. We also added a provision that the attorney must be required to meet the respondent at least 7 days prior to the hearing. We've heard many, many stories from individuals that, first of all, they didn't even know there was a hearing. They weren't even aware that there was guardianship proceeding being filed against them. They had no opportunity to attend the hearing or speak for themselves, and that if they did have an attorney, if they did get the privilege of going and had an attorney, that attorney often met them in the hallway 5 minutes prior to the hearing. And so we added a provision that said you need to at least meet that person and find out what it is they want. So we added provision that professionals other than physicians with experience or training in the impairment can be included in the evaluation. Right now what happens is there has to be a physician who signs off that this person lacks capacity or needs a guardian. Oftentimes that might be the family physician who is treating that individual for kind of minor kinds of illnesses, but doesn't really feel comfortable making a decision about capacity, or doesn't feel like they have enough information about the individual to make those kinds of decisions. So we added some other people who could do that, and we also beefed up the notice that's required so that hopefully individuals have the opportunity to know that there is a proceeding for guardianship and have the opportunity to attend and have representation. Let's see. We said before appointing a guardian or conservator, the court must rule out any available alternatives. So we want them to look at, is there another alternative or option out there that can meet the support needs of this individual before you appoint a guardian or conservator. Again, trying to just stay at the least amount of support and protection a person needs before going to full, more restrictive kinds of guardianships. We spelled out that they need to look at the agents under durable power of attorney. Can this person's support needs be met by a power of attorney? If it's financial, is there a way to set up a trust to meet the financial needs of the individual? Is there assistive technology out there that helps with whatever the level of protection and support a person needs? Is there support of family and friends, like supported kind of decision making? And are there representative payees for income benefits that would help? And appoint a limited guardian or a limited conservator if appropriate, and then again appoint a full guardian or conservator only as the last resort after these options have been exhausted. Under the administration of the guardianship itself, we kind of combine the standards of best interest and substituted judgment to really act in the best interest of the individual, considering their preferences. You should take into account what that person wants. In their required decision-making process, we say the guardian should ask the ward what it is that they want. If the ward has difficulty expressing what they want, the guardian should do everything possible to help the person express their preferences. And if the ward with assistance cannot express their wants, the guardian would seek the input from people familiar with that person to help determine what it is that individual would want to have happen. We added a provision that there is a plan required within 90 days of the appointment. And under our current law, there is a plan. If I become somebody's guardian, I'm required to file an annual report with the court at the end of the first year of that guardianship. We added a provision that a plan would need to be put in place within 90 days of the appointment because, again, we want them to get to know that individual, to understand where they want to live, what their preferences are, and submit a plan to the court that says, this is my plan for supporting this individual for the next year. Not wait a whole year and then say, these are the kind of things I've done, but have that upfront plan. Let me see. They should make a good faith effort to cooperate with fiduciaries, other people that are involved with their money. We added some provisions about substituted judgment for healthcare decision making. Again, asking that they maximize the ward's participation and understanding, that they encourage the ward's direction, and if not, encourage to make decisions based upon the individual information of the person's values. We added a new section on the rights of the ward, since there is none in our current law, and we all felt that was very important. So we said the person needed to have a right to a guardian who acts in their best interest. They need to have a guardian who is reasonably accessible to the ward. We have had many stories from individuals who say that they've never seen their guardian. They don't have a way to get in touch with them if they need or want something or have concerns, that they have difficulty getting in touch with them. So they should be reasonably accessible to the ward. They should have the right to communicate freely and privately with family, friends, and others besides their guardian. And we had a big discussion about this. I will say that we had robust discussion among our stakeholders group on many of these issues. And part of some of the things that the public administrator shared with us is there's sometimes that right needs to be restricted. If that individual is the one that is perhaps detrimental to that individual or encouraging them to do things that they shouldn't be doing or those kind of things. So we did add a provision that they should be able to communicate freely and privately unless that needed to be limited for safety or therapeutic reasons. So if you can make a case why there's a reason that they shouldn't communicate with that individual, then that can be limited. They should have a right to the least restrictive form of guardianship assistance. They should have a right to be restored to capacity as early as possible. And I think there are many, we heard from many public administrators that is occurring, that they do start working with individuals about helping them get the skills and supports they need to have that restored. But we want that to happen for everybody. And they have a right to receive information from the court about what their rights are and how they can petition if they have guardianship and they want to have their rights restored. That's kind of hard if you already have a full guardian, because sometimes you don't have access to your money. So they need to know from the court about what their rights are to be restored and what they need to do to engage in that process. I know less about this because it's about the money, but we made some changes to the standard for conservator financial decisions. Again, trying to maximize the dignity, autonomy, and self-determination of individuals about exercising rights around their money. We said that if there was a current estate plan in place, it should be accommodated if possible. And some of this stuff is around issues for people who are aging. And also gifting permitted, like if they have given gifts to their children in the past and that's a practice they engage in, that should still be permitted. And we did some clarification and coordination around marital assets. Again, about the restoration and termination, the petition to increase or to decrease the guardianship and conservatorship powers. Let's see, we made some changes around that petition. We made some changes around the termination of the guardianship and conservatorship, because some of the public administrators and others who have these big caseloads told us that oftentimes a person just leaves their jurisdiction. They can't, they move to another state or something, they don't notify them. So they're still on their caseloads and they're still required to do reporting on them, and they may not even know where that individual is anymore. So we made it easier to terminate the guardianship in case of death or restoration or disappearance. We tried to streamline that process. For the restoration, if I have a guardian and I want to get my rights back, if the guardian and the ward agree, we made a provision that there would be no court hearing required for that. So we tried to simplify that and make that easier. Of course, if the guardian and the ward do not agree on that, a hearing would still be necessary. But, if my guardian and I say, we think you're fine to have your rights restored, then no hearing is necessary. And then we streamline the process if the ward or protectee dies. So, next steps, kind of some of that's changed. As I said, we really engaged in a very strong effort and did a lot of hard work to make these changes and recommendations. We did over 32 public presentations around the state to seek input from others and have people share their opinions with us and tell us what they thought. We made some changes based of our recommendations based on that input. We've had a website that's up and operational that has our proposed changes to the law. It is on that website, so everybody can go on that website and look at them. As I said, it's kind of complex. It's now 138 pages long, so it's gotten even longer. But we've done the presentations, got the website. So good news is we have a sponsor. The recommended changes were just introduced in the Missouri House of Representatives last week. The bill number is House Bill 2778. And Representative Neely, who is a physician up in Northwest Missouri, is the bill's sponsor. So we would encourage you all to go take a look at this legislation, see what you think. If you believe these changes are important and are beneficial to the people that you support and that you care about, we need your help. There will be, of course, has to go through the legislative process. It's a statutory change, so there will be hearings, and we will need to have families and individuals and people who support them that believe in this come and testify. And then, of course, speaking with your local representative and your local senator about these kind of barriers and challenges and how this new law would be helpful, would be very, very helpful. We anticipate this being probably taking at least another year. It was introduced kind of late in the session this year, and so hopefully we're going to hope to at least have a hearing this year on it. But But really, we're expecting the major part of the work to happen next year, next legislative session. So, with that, Ben will answer any questions you have. Forget one thing. There are other members in this audience who helped and who is engaged in this work, and I would ask them all to stand, please, and be recognized, because this has been a lot of work. We appreciate the input and the participation in everybody.
So I won't answer all the questions because I don't know all the answers, but we'll note them and get the responses we need. I just want to put a context on this. We started this process probably 7 years ago, and we started it from the vantage point of saying we needed to do training in the state on alternatives to guardianship. And so the council funded a series of training opportunities that went around. And, you know, it can only go so far in terms of reaching parents and teachers and others. And it was a great start, and it continues on today. Then we started saying there's going to be some systemic things that we need to do, because part of this issue really comes back to when the decision is made that someone should go under guardianship. And so we decided that maybe what we ought to do is take a look at the statute and see what we can do. And that's the process we've been engaged in for the last 4 years now, I think. And it's been a yeoman's task, but I don't want to have us think that the work is done because the statute has changed. As our illustrious speaker mentioned today, there is nothing in the law today that really ultimately would prohibit us from accomplishing these things, even with the way it's worded now. It really is dependent on the implementation at the various jurisdictions where those decisions are made. What we tried to do with the statute was to minimize some of the discretion, or to tighten up some of the discretion that we find that takes place from jurisdiction to jurisdiction, and really focus on some of the new things, best practices that we've learned over the last 20 years, and incorporate those. We started with education. We're doing the statutory change, and we hope that that will go through and that will have an impact. But ultimately, it comes back to education and sharing with one another why this is important, the value of recognizing that individuals' rights are something that they should retain regardless of whatever disability they might have, that support really is the key element in terms of decision making. And as you can see, a lot of the changes that we try to incorporate, the focus was on a person's capacity to be engaged in decision making, supporting the tools that we develop. All of it is about coming back to this notion of how do you support individuals to make decisions that are important in their lives. And hopefully we can look at all these alternatives before it gets to guardianship, and that guardianship really does become the last resort. And if we're looking at guardianship, then it becomes limited guardianship, because the courts have total discretion when they write the order which part of decision-making support really needs to be supported. They don't have to go to plenary total guardianship ever. That's really up to their discretion. So education, talking with one another, this is where all of us come in. You know, it won't change unless we, in our local communities, in the situations that we become familiar with on a day-to-day basis, unless we begin to say, why are we doing this to this person? You know, what's the logic behind this? And it's when you start questioning at that level that change actually begins to take place. So are there any questions that you have that we can't answer? If not.
Yes, ma'am. Will you guys be posting when you do learn of hearings? I'm just wondering, when you do learn of any hearings, will you be posting them on the website, or how can we find out when those hearings are? So if we want to submit written testimony, we can do that.
Good question. Yes, we will post
We will post updates on the status of the pending legislation, when any committee hearings are going to be held, in which it would be good to have advocates there, or just to let everybody know. If you don't like it, you know, that's our legislative process. That's the opportunity for you to come and share your concerns as well. But we'll be posting that on the MOAAIDD's website, and that is www.mo-wings.org. The DD Council will also be sharing that with our networks. We'll have that information on our website, and we'll be sharing that out with our listservs and with all of you, so you can hopefully participate with us in that effort, or share it with families, share it with individuals with disabilities that you know, and provide supports to, so they have an opportunity to engage in that process.
Any other questions? Thank you.
Thank you.